Welcome back to NYAY PATHSALA. Remember, knowledge is power. Today, we'll be discussing the concept of dying declaration as provided under Section 32(1) of the Indian Evidence Act 1872. So, at the very inception, let us look into this provision. Section 32 of the Indian Evidence Act starts with the statements by person who cannot be called as witness. Section 32 states that in cases in which statement of relevant fact by person who is dead or cannot be found, etc., is relevant. So, statements, whether it is written or verbal, of relevant facts made by a person, there are 4 criteria which has to be fulfilled. Number 1, who is dead. Number 2, who cannot be found. Number 3, who has become incapable of giving evidence, or number 4, whose attendance cannot be procured without an amount of delay or expense under the circumstances of the case appears to the court unreasonable, are themselves relevant facts in the following cases. Number 1, when the statement is made by a person as to the cause of his death. Remember carefully, if a statement is made by a person as to the cause of his death or as to any of the circumstances of the transaction which resulted in his death, in cases in which the cause of that person's death comes into question. So, Section 32 refers to 2 kinds of statement. Number 1, when the statement is made by a person as to the cause of his death. Number 2, when the statement is made by a person as to any of the circumstances of the transaction which resulted in his death. Section 32 contains many important exceptions to the rule of hearsay statements. Hearsay statements are of 2 types. Number 1, individual hearsay. Individual hearsay is regarded as an extrajudicial statement which is essentially second-hand information. Individual hearsay refers to a statement made by a person not testifying at the trial, but it is repeated by a witness during his testimony. Let us take an example. A tells B that she saw a crime, and then B testifies in court about what A say. This is an example of individual hearsay. Now, what is composite hearsay? Composite hearsay may be defined as a compound or blended extrajudicial declaration. This involves multiple layers of hearsay where a statement has passed through several people before being repeated in testimony. It's like a chain of second-hand information. Let us look into one example. A tells B about a crime. B tells C, and then C testifies in court about what B told him A said. In the Indian Evidence Act, the cardinal rule is that the best available evidence should be brought before the court to prove a fact or the points in issue. Today, we'll be only concentrating on Section 32(1) of the Indian Evidence Act, which does not use the word dying declaration. It uses the word statement, which is not defined in the Act. So, what is statement? Statement means that which is stated. If you look at Section 32(1), it deliberately avoided the use of the word oral as used under Section 60 of the Indian Evidence Act. Section 60 of the Indian Evidence Act states oral evidence must be direct. When we talk about Section 32(1), it uses the expression verbal. You must remember that it is not necessary that the words should be spoken when you talk of Section 32(1). Under Section 32(1), the words of another person may be adopted by witness by a nod, gesture, or a shake of the head, or any sign language. Let us look into one of the judgment of the Supreme Court, which is Misala Ramakrishnan versus State of Andhra Pradesh, reported in 1994 4 SSC 182. In this case, The Supreme Court had accepted that the dying declaration on the basis of gesture not only as admissible but also possessing evidentiary value. The statement was recorded in this case by the magistrate and a certificate of mental condition was appended by the doctor, who had stated that the nods given by the deceased were effective and meaningful. So the dying declaration formed the sole basis for conviction in this case. Let us look into another scenario. The questions are put to the injured person who is unable to speak, and the signs made by him in reply taken together amount to verbal statement within the meaning of this section. Wherever the dying declaration is oral, remember, the exact words stated by the deceased to the witness are of utmost importance. A dying declaration need not have been made in the expectation of death. But one of the important criteria the declarant must satisfy is that he is a competent witness. And what is competent witness is enumerated under section 118 of the Indian Evidence Act, where you find who may testify in court. So the foundation of section 32 is that the death of a person has to be proof. There is no requirement of law that such statement must necessarily be made to a magistrate. Remember it. A dying declaration made by a person on the verge of his death has a special sanctity, as at that solemn moment a person is most unlikely to make any untrue statement. The shadow of impending death is by itself the guarantee of the truth of the statement of the deceased regarding the circumstances leading to his death. But at the same time, the dying declaration, like any other evidence, has to be tested on the touchstone of credibility to be acceptable. It is more so as the accused does not get an opportunity of questioning the veracity of the statement by cross-examination. You may look into the judgment of Narayan Singh versus State of Haryana, reported 2004-13 SCC 264 para 7. There is another judgment also you may look into 2012 6 SCC 606 paragraph 16 to 18. The name of the parties is Salim Gulab Pathan versus State of Maharashtra. The whole concept of this admissibility of dying declaration rests upon the principle of, this is a Latin expression, nemo moritatis presumptoria menteria. Listen again, nemo moritatis presumptoria menteria. What it means? A man will not meet his maker with a lie in his mouth. To understand this, kindly look at illustration A of section 32(1). I am reading it slowly for you. The question is whether A was murdered by B or A dies of injuries received in a transaction in the course of which she was ravished. The question is whether A was killed by B under such circumstances that a case would lie against B by A's widow. In this case, the statement made by A as to the cause of his or her death, referring respectively to the murder, rape, and the actionable wrong, are relevant facts. So I would request my viewers to read this illustration A to the section 32(1). The next question that comes up to my mind is that what is the rationality for admissibility of dying declaration under section 32(1) as evidence? As per the maxim nemo moritatis presumptoria menteria, which means a man will not meet his maker with a lie in his mouth, dying declaration under section 32 is admissible as evidence. And this has been discussed in some of the judgment of the Supreme Court. You may look into it. One is 2007 10 SCC 371 Sundarlal versus State of Rajasthan. The second is Dharampal versus State of UP 2008 17 SCC 337 paragraph 17 to 19. Now, when you talk of section 32(1), The next question that definitely comes into our mind is that who must prove that the person is dead? If you look at section 136 of the Indian Evidence Act, illustration A, it states that if it is proposed to prove a statement about a relevant fact by a person alleged to be dead, whose statement is relevant under section 32, then the fact that the person is dead must be proved by the person proposing to prove the statement before evidence is given of the statement. So kindly read section 104 of the Indian Evidence Act along with illustration A, which provides the burden of proof by stating that if A desires a court to give a judgment that B shall be punished for a crime which A says B has committed, then A must prove that B has committed the crime. Death as such has been defined under section 46 of the Indian Penal Code. And section 46 of the Indian Penal Code defines death as the word death denotes the death of a human being unless the contrary appears from the context. We should remember that for applicability of section 32(1), the foundation is the death of a person has to be proved. Now imagine a situation. What happens if a person giving such a statement survives? In that event, statement will not fall under section 32 and cannot be used as a dying declaration. Why? Because the ingredients of death are removed. So I put myself under a question in this way. Say for example, if the maker of the statement made to a magistrate under expectation of death but survives, in that case, can the statement be admissible or used as an evidence under section 32 of the Indian Evidence Act? The answer to this query is given by the Honorable Supreme Court in the case of Ram Prasad versus State of Maharashtra, reported in 1999, 5 SCC 30 para 14. The Supreme Court held that the statement of a person surviving cannot be used as an evidence under section 32, though it was recorded as a dying declaration. At the time when the witness gave the statement, he would have been under expectation of death, but that is not sufficient to wiggle it into the cassette of section 32. So we should remember that as long as the maker of the statement is alive, it would remain only in the realm of a statement recorded during investigation. So the question is now is that whether there is any legal requirement that the dying declaration would be admissible in evidence only when the same is made in expectation of death. Kindly listen to this question. Whether there is any legal requirement that the dying declaration would be admissible in evidence only when the same is made in expectation of death. You should look into the judgment of 2004 13 SCC 249 B Shashikala versus State of Andhra Pradesh, paragraph number 17. In this case, the Supreme Court observed that it is not necessary that the dying declaration would be admissible in evidence only when a statement is made in expectation of death. The law does not say that section 32 of the Evidence Act is an exception to the hearsay rule. So the question is that can dying declaration be recorded in a language other than the one in which it was made? Because sometimes the witness may know Urdu, the dying declaration may be recorded in English. In that case, in the case of Hosan versus State of Andhra Pradesh, reported in 2002 7 SCC 414, the Supreme Court held that where the statement was recorded and signed by the magistrate and an endorsement was made thereon by the doctor, that the deceased made the statement in a fit state of mind, and the deceased put her thumb impression, which was made in Urdu and recorded in English, and thereafter explained in Hindi to the deceased. In that case, the Supreme Court held that the High Court was justified in holding the said dying declaration to be reliable. When we are in college, we are always told that the dying declaration, when you associate dying declaration, it is only with criminal law. But we must remember that section 32(1) also applies to civil proceedings. In case of dying declaration, the question that normally crops up is that who can record a dying declaration? This is very important. The answer is that any person, including the police and the doctors, can record a dying declaration. In one of the cases, the doctor was the best person to opine about the fitness of the deceased to make the statement, and he did. The doctor found that life was ebbing past in the patient. There was no time to call the police or a magistrate. In such a situation, the Supreme Court observed that the doctor was justified. Indeed, he was duty-bound to record the dying declaration of the deceased, as he was a disinterested, respectable witness. You can also look into the case of Abdul Majid Abdul Rahman versus State of Gujarat, reported in 1976, 4 SCC 351. Sometimes the question put is that whether dying declaration can be rejected in the absence of a doctor's certificate about the mental fitness of the deceased who is making the statement. The answer is no. A dying declaration cannot be rejected solely on the ground that the person recording the statement is satisfied that the declarant was in a fit mental condition to make the dying declaration. This has been reiterated by the Supreme Court in the case of Rambai versus State of Chhattisgarh, reported in 2002, 8 SCC, page 83, paragraph number 6. In my screen, I will be giving a list of citation, and for your research work, you can pause this screen and take note of this citation, and you can read it to apply it to the facts of your case, because different facts and circumstances, sometimes the principles are tweaked. So I have given a list of citation of all the cases of the Supreme Court. You will look into it, including the criminal rules of practice. So what is the proof required to admit a dying declaration in court? First, a dying declaration may be proved by the evidence of a witness who heard it being made. Second, we must remember that a conviction based upon an uncorroborated dying declaration is also legal, because there is neither any rule of law nor of prudence that a dying declaration requires to be corroborated. Similarly, in case of burn percentage, there is no hard and fast rule of universal application on the question whether the percentage of burn suffered is the determining factor to affect the credibility of the dying declaration and the improbability of its recording. In case of dowry death, normally, the decisive factor would be the quality of evidence about the fit and conscious state of the declarant to make the statement. So it is often asked that can dying declaration be the sole basis of conviction? In that case, you should look into the judgment of Voju versus State of MP, reported in 2012, 4 SCC 327, paragraph number 22. In this case, the Supreme Court observed that the law is very clear that if the dying declaration has been recorded in accordance with law and it's reliable and gives a causable and possible explanation of the occurrence of the events, then the dying declaration can certainly be relied upon by the court, and it could form the sole piece of evidence resulting in the conviction of the accused. In the same judgment, in paragraph 28, it refers to other judgment. You can kindly take note of it, that in regard to the principles, they have in the judgment it has referred to 2006 9 SCC 240, then 2008 2 SCC 516, 2001 SCC page 310, 2001 6 SCC 118, and 2002 1 SCC 577. You can look into the judgment to have a complete and clear understanding of this concept, how the dying declaration has to be proved in court. Sometimes, where for unexplained reason, the writer of the dying declaration or the scribe was not produced for examination and as well as for cross-examination. In that case, the written dying declaration cannot be held reliable. You must always remember that dying declaration should be precise. It should be short, concise, and to the point, and it should be complete. If question and answers are elicited, then it should be written. As we conclude our discussion on dying declaration, it is important to remember the importance of which is rooted deeply in the belief that a person on the brink of death speaks the truth. Thank you for joining us at NYAY PATHSALA, and always remember that justice will find its path through the voice of the silence. If you are passionate about understanding various concepts of law and justice, subscribe to NYAY PATHSALA and join our community. We have covered the fundamentals of the dying declaration and the various citations of the Supreme Court. Once again, thank all our viewers for watching our series on law.